Attorney Jeffrey Moots and Assistant Attorney General Nelson Werner were engaged in a heated debate in court today in the Blue House prostitution case. Guam police officers David Manila and Anthony Kenga and the bar's owner Song Ja Cha were scheduled for an arraignment to answer to the charges in the third superseding indictment filed last Friday. But Moots refused to answer the charges for his client, Song Ja Cha, disputing the Superior Court's authority to preside over the case.
But the case is now before the Supreme Court of Guam, which took the Superior Court's jurisdiction away, including the ability to do a superseding indictment. They could have filed a brand new case, I guess, and tried it that way. But under using a superseding for the same case number, the divestiture rule would mean that case was no longer in the Superior Court, which means Mr. Warner had no jurisdiction to do what he did. And this court has no jurisdiction to take a plea at this time.
But Werner notes that the appeal Cha filed was an interlocutory appeal, not a traditional notice of appeal. An interlocutory appeal means that an appeal of a ruling has been filed before a trial has concluded. Werner argues that the Supreme Court still needs to decide whether it will even accept this kind of appeal.
Our position is, Your Honor, that the appeal filed by Defendant Cha was an interlocutory appeal. And in order to effectuate a stay of the proceedings in the lower court, a motion to stay in the lower court is required before the stay goes into effect. No motion to stay was filed, and we have not heard from the Supreme Court whether they're even going to consider the interlocutory appeal.
That's a great position, Your Honor, but if you'll note he doesn't cite any rules, statutes, or Supreme Court opinions to support that rule.
This would be an issue that would be raised with the lower court at this point, Your Honor. We have a hearing.
Actually, it would not. It would be raised with the Supreme Court of Guam, which now has jurisdiction over the case. That's the point. Mr. Warner seems to be unfamiliar with the law of Guam and is making arguments that are not based on any law of Guam.
Well, the Supreme Court has the ability to indicate whether they, in fact, are going to take an interlocutory appeal or not. At this point, the Supreme Court has not spoken at all with respect to this interlocutory appeal.
Actually, the Supreme Court has. In Saline, it says once a timely notice to appeal has been filed. It doesn't say once the Supreme Court notifies Mr. Warner that it's accepted the notice of appeal and is going to hear the case.
Magistrate Judge Alberto Tolentino delayed Cha's arraignment to next Wednesday, March 27th, to give the court time to review the matter. Meanwhile, Manila and Kenga, accused of having sex with Blue House Lounge employees, have entered conditional pleas of not guilty.
We'll object to the jurisdiction of this court, Your Honor. We'll have a conditional plea of not guilty.
We are objecting to jurisdiction, but we conditionally enter a plea of not guilty.
Manila's defense counsel, attorney William Pohl, tells PNC that he plans to file 2 additional motions.
We believe it was inappropriate to believe the third superseding indictment, that the charges are inappropriate. And
there are actually less charges now. I believe they've removed some of the solicitation charges.
That is correct, but they increased the charges only after my client has asserted certain of his rights, which again we believe is prosecutorial vindictiveness, which is inappropriate.